S-T-E-P-H-E-N, capital S, lowercase M-I-T-H.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024.
Right here, Judge Bradley is laying out the roadmap. Admit responsibility, explain with mitigating factors, or deny everything and proceed to testimony. This is where a lot of sovereign citizens go off the rails instead of addressing the... Notice how she emphasizes the preponderance of evidence. Standard, that's only 51% certainty needed to rule against you. This isn't beyond a reasonable doubt, like in criminal cases. Civil infractions are much easier for the court to decide on. So my question to you, if you were in his shoes, would you own up, explain, or roll the dice and deny responsibility?
That charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL. So it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Okay, thank you. Just a moment. Mr. Smith. As you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
And there it is, he denies responsibility. Classic sovereign citizen move. Instead of taking one of the straightforward paths, he pivots with a request, making the court a trustee. That's a strategy we often see in sovereign circles, creating complicated titles and labels to challenge jurisdiction. Judges usually brush this aside because it has no basis in actual law. What's key here is the judge's patience. She keeps things moving by focusing on testimony, not the theatrics. This is where the drama really begins. Once sworn in, both sides have their chance to present evidence, and the judge will weigh which story holds more water.
Okay.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay. So if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint.
Now, this ruling is fascinating. The judge actually cuts him a break on the window tint, finding him not responsible because the evidence wasn't strong enough. That might feel like a win, but watch the balance swing the other way. When it comes to the gun disclosure, Judge Bradley doesn't hesitate. Guilty. Why? Because Michigan law is crystal clear. If you're carrying, you must disclose immediately. The law doesn't leave room for interpretation. That's why she issues the $500 fine and a 6-month suspension of his concealed pistol license. For anyone watching who carries legally, take note. The tiniest oversight can lead to serious penalties.
Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction. For a first offense, there's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
at this point, the court has made its ruling. This hearing is concluded. I believe that concludes the.
Someone named Steph that was just let into the courtroom. Can you please tell us your first and last name? Please unmute your device.
My name is spelled capital S, lowercase t, lowercase e, lowercase p.
Sir, please tell us your name? And I didn't ask you to spell it.
My name is Stephen Smith.
Thank you. We'll call the matter of Ypsilanti Township versus Stephen Smith, case number 24W003208A.
Paul Barnett on behalf of the township.
Here's where the plot twists. At the appeal hearing, the officer who issued the ticket doesn't show up, he's on vacation. In legal terms, that's a game changer. Without the officer's testimony, the prosecution's case collapses. Judge Washington quickly points out the state can reauthorize charges later, but for now, she has no choice but to dismiss this. This is one of those moments where sovereign citizens feel vindicated. They think their arguments worked, when in reality, it's pure procedural luck. And it raises a question for you. Should cases like this be dismissed if an officer can't appear, or should the state get more leeway to reschedule?
All right, we're hearing an appeal today. Mr. Smith filed a claim to appeal in this particular matter.
That's correct, Your Honor. I did reach out to Deputy Sims, who is the officer needed to hold this hearing, and he replied to me that he was not available. He's on vacation and out of the state. So I'm asking for an adjournment of the hearing.
Thank you. Mr. Smith, what is your response, sir?
He failed to appear, so I'd like the case to be dismissed.
All right, so this is carrying a concealed weapon, and he has a concealed weapons license, but he failed to disclose it to the officer. That's what the ticket is.
I believe that's correct, Your Honor.
And Mr. Smith, you understand, sir, that if it is dismissed, they could reauthorize these charges?
No, I don't understand.
All right, well, now I've told you. Now do you understand that, sir?
I don't exactly. I can't say I understand, but I get what you said, but I don't understand the means behind it. So,
Well, that's what the law allows for, any dismissal without it being on the merits of the case. It's without prejudice. Without prejudice means that the prosecution has the ability to reauthorize it.
okay.
Okay. And so is that what you're requesting right now?
Yes, a dismissal.
Mr. Barnett, I think what's going to have to happen in these cases is if you're not going to be able to proceed, you may need to send in a formal request ahead of time so that the court is aware of that.
Understood, Your Honor. Yeah.
I'm going to allow them to have it dismissed. All right. Sir, this case will be dismissed. It's probably going to be reauthorized. But at this time, your bond will be returned, okay?
Thank you.
And there you have it. The sovereign citizen walks away. Case dismissed. For now, but let's be clear, this wasn't a win for sovereign ideology. It was simply the officer's absence that killed the prosecution's case. The judge even warned, dismissal without prejudice means the charges could come back. Still, for this defendant, it feels like a huge victory, fines overturned, license potentially restored, and the case wiped clean, at least temporarily. So what can we learn here? First, always disclose your concealed weapon if you're stopped. It's the law, and it's about officer safety. Second, never mistake procedural luck for a legal strategy. And finally, these courtroom battles reveal just how fragile cases can be when one piece of the puzzle, like an officer's presence, falls apart. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, you won't want to miss the next one.